Hi there. I'm attorney Kelly Longtin, and welcome to our YouTube channel at Kelly Longtin Law. And today I want to talk to you about what to do when you do not own what you actually think you do. So imagine this scenario. You've been living in a house for years as your mother's sole heir. You inherited it from her when she passed away. You pay the taxes and the insurance, you make repairs, and you mow the lawn. You call it home, and everyone in the family calls it yours. However, when you decide to sell, a harsh reality surfaces. Your name is not on the deed. While it may feel like your home, it is not actually yours as far as the bank is concerned. It never was, and because it's not legally yours, you cannot sell it. So, how did this happen? You assume that everything was handled years ago. You start digging and learn that not only do you not own the home, but you could lose it as well. A distant relative you barely know could claim a share, or maybe, just as worrying, the state could step in to redistribute it according to state law. You find yourself suddenly facing a legal crisis you never saw coming, and you need to fix it fast. Well, scenarios like this one are more common than you might realize. From unrecorded deeds to accounts held solely in a deceased spouse's name, many people discover too late that what they thought they owned is not legally theirs. When that happens, the fallout can be costly, time consuming, and deeply disruptive. It's a nerve wracking proposition to consider what we think we might own not to be ours. And this issue can arise in the context of an inherited account or property, in which case important documents may have fallen through the cracks of estate administration. However, it also happens in co ownership arrangements, whether between spouses, family members, or business partners. The old saying that possession is 9/10 of the law does not, in most situations, hold much weight in court. If a property such as a home was meant to be yours, but it has not been properly transferred into your name, simply living in it will not protect you. You will need to identify what went wrong and take action to correct it. The problem often stems from an incomplete or poorly executed estate plan. For example, in the case of a home that you've lived in for years but do not legally own, here is what might have gone wrong. The home may have been left to you in a will, but probate was never opened to formally transfer title. Maybe there was no will and no open probate for the court to determine who is legally entitled to the home based on state intestacy laws. Maybe the original owner intended to have a deed drafted to transfer the property at their death or into a trust, but never followed through with it. Or maybe there was a verbal promise, this will be yours someday, was not backed by legal documents. While your perceived ownership may not be legally valid, the potential consequences very much are. So let's talk about some common consequences of not checking to ensure that the property you thought you inherited was actually yours. Well, the first is you cannot sell or refinance the home. Without your name on the deed, title companies will not allow you to sell the home, and lenders will not recognize your authority to take out a loan. There's insurance issues. Your homeowner's policy may be void if you're not the legal owner, and the insurance company could refuse to pay out on any of the claims. Now, there's family disputes. There's other family members or heirs may have a claim to the property, and you could lose all the money that you've spent maintaining the home. And then there's creditor exposure. Because the home is still titled in the deceased owner's name and remains part of the estate, the deceased creditors may be able to come after it. Their success in doing so will depend on how much time has passed since the deceased owner's death and whether the deadline for the filing the creditor claims has expired. To fix the situation, you'll likely need to take some of the following steps. Maybe you need to open a probate case in the state where the property is located to formally transfer legal title. You may need to prove that the deceased owner's will, if there was one, is legally valid and determine whether you are legally entitled to inherit the property. If there's no will, determine who is legally entitled to inherit the property under state law. After probate concludes or as part of the probate process, depending on your state's probate procedures, a new deed will be recorded transferring the property to the person or people legally entitled to it. So ideally, this means you. Now, the cost to open a probate proceeding with the end goal of recording a new deed could easily be tens of thousands of dollars. However, costs could escalate beyond that if there's a lapse in insurance coverage, and if you file a claim or somebody else asserts a right to the property, then you end up in litigation to settle who is entitled to that property. Now, to avoid these issues, anyone who believes that they have inherited real estate should contact an attorney to verify that they are the rightful owner and to ensure that a proper deed is created and filed to reflect their new ownership as a result of the original owner's passing. You should also work with an attorney anytime you inherit anything of significant value or add accounts or property so that you can properly account for it in your estate plan. An experienced attorney can help you catch and correct issues before they become legal or financial crises, either for you now or for your loved ones later. About what happens when you think you own property together. Well, Robert always handled the household finances. He managed the bills, balanced the checkbook, and paid the mortgage from a checking account in his name. His wife, Maria, had always assumed that the account was theirs because it was used to pay for both of their expenses. But she was wrong. When Robert passed away and Maria tried to access money in the checking account, the bank told her that she has no legal right to the funds in it. Their bills were still coming in, but the money from their account was not. It did not matter to the bank that Maria was Robert's wife or that they had shared a life together. She was not listed on the account as an owner, and that meant the funds were locked away, and she needed to take legal action in order to access them. So let's talk about some of the consequences of of something that went wrong and what may have actually gone wrong. Well, the primary household account was titled in one spouse's name only, so by default or convenience, and the couple just didn't even realize it. That happens a lot. Now, the couple may have intended to add the non-owner spouse as a joint owner or designate them as a beneficiary, but they just never followed through. Another possibility is that the account did not have a payable on death or a transfer on death designation, leaving no clear path for that transfer. Maybe the account holder believed that their spouse would automatically inherit the account by being their spouse, or that their will, naming the spouse as a beneficiary, would control distribution without the need for probate court. So some of the consequences of this era. While there's a financial disruption for the spouse, the survivor who now does not have immediate access to these funds may be unable to pay for rent or mortgage, groceries, utilities, or other essentials. Then we have frozen funds. Accounts in the deceased sole name may be frozen until probate has been opened. Then we have the added stress. Now, these issues arise when a spouse is already grieving and emotionally vulnerable. Then we have legal delays and potential expenses. Even if the funds are eventually released to the spouse, the remedy requires time, paperwork, and possibly court involvement. So let's talk about how to fix this mistake and how to prevent issues in the future. First, the surviving spouse will likely need to open a probate case to gain access to those funds. Now, in some states, affidavits or similar claim forms can offer a quicker alternative to a full probate, especially for smaller accounts and smaller estates. Now, let's talk about how to prevent issues in the future. Well, you want to review the ownership and beneficiary designations of all of your accounts, especially the critical ones used to pay for everyday expenses, and ensure that the right people have access during an owner's incapacity and upon their death. So consider taking the following steps. You could add a joint owner, you could name a POD or a TOD beneficiary, or you could include the account in a revocable living trust. Either way, you'll want to work with an attorney to coordinate titling, estate planning documents, and access strategies to avoid unintended lockouts or delays. Now, financial institutions do not recognize good intentions. They follow legal paperwork. That is why ensuring that your accounts reflect your estate plan and not just your assumptions is so important for protecting your spouse and other beneficiaries. Now let's talk about what happens when you think you're the sole owner. Well, for example, brothers Mark and David invested in a rental property together years and years ago. They always assumed that if something happened to one of them, the other would simply inherit the deceased brother's share, allowing the remaining brother to continue owning and managing the property seamlessly. However, when Mark passed away, David was shocked to learn that Mark's 50% share did not automatically go to him. Instead, it became part of Mark's estate, and his estranged adult son ended up owning half of the property. Now, in this circumstances, clearly something had gone wrong, or at least not as each of these people intended. Maybe the deed listed the owners as tenants in common. This form of ownership means that each owner owns a distinct, separate share of the property. With this type of ownership, there are no rights of survivorship, so each co-owner's share passes according to their will or intestacy laws upon their death, not automatically to the other co-owners. One co-owner dies without updating their will, or worse, without a will, leaving their share to someone the other co-owner never intended to deal with. Now, this can lead to lots of consequences, as you can imagine. There could be unexpected co-owners. So you could end up sharing the property with a relative of your deceased co-owner who wants to sell or use the property in a way that you disagree with. Now, there's opening the door for legal disputes. Disagreements between unintended co-owners over how to use or maintain the property can lead to long and costly court battles. Then you have partition actions. If the new co-owner wants out, they could force the sale of the property through the court, regardless of whether you want to keep the property. Partition actions can be expensive and could force the sale of the entire property, not just the disputed share. So let's talk about some solutions if that circumstance were to happen to you. Well, you may need to negotiate a buyout of the new co-owner's interest after the property has gone through probate and the new co-owner takes title. Now, where cooperation is not possible, a petition action can be filed in court to legally sever the co-ownership or force a sale. In order to prevent issues in the future, you want to review the ownership language on the deed for any jointly owned property. Property that lists tenants in common may no longer be in your best interest or match your goals. Now, if you want your co-owner to automatically inherit your share, you may need to change the deed to joint tenancy with rights of survivorship, or include a provision in your will or trust that gives your interest in the property to your co-owner. Now, co-owning property can make sense and work well while all co-owners are alive, but only when the ownership structure matches your intentions. If it does not, or if your intentions change, but your estate plan does not change to match them, you could be saddled with a property partner that you never wanted and a legal mess that you did not see coming and could not easily get out of. So let's talk about other hidden ownership traps and how you may want to avoid them. Real estate and financial accounts are not the only things that people may think they own without truly owning them. Misunderstood or incomplete owners can show up in other places as well. So limited liability company or business shares. Maybe you co-founded a small company and helped it grow, but you never signed an operating agreement or had your ownership interest documented. On paper, you might not own a thing. Let's talk about your personal property. So heirlooms, vehicles, or collections passed down informally and not legally transferred through an estate plan can trigger disputes amongst heirs or be claimed by creditors. Then there's insurance and beneficiary designations. Life insurance policies with no listed beneficiary or outdated ones that do not reflect the owner's current wishes may default to the estate or go to an ex-spouse or estranged relative. Now, the complexities of property and inheritance laws, probate and trust administration, in addition to the human error factor, can turn what seems like a straightforward transfer into a transactional nightmare. You don't want to wait for a crisis to find out that you do not own what you think you do. So you want to meet with an estate planning attorney from the start to accurately determine the legal ownership of any accounts and property you think you own or you have inherited, so you can fix any mistakes before it's too late and ensure that your estate plan transfers to them and to the intended beneficiary in the manner in which you have intended. So you don't want to wait for a crisis to find out that you don't own what you think you do. Work with an attorney from the start to accurately determine the legal ownership of any accounts and property that you think you've owned or inherited, so that you can fix any mistakes before it's too late and ensure that your estate plan transfers them to the intended beneficiary in the manner in which you intended it to do so. So if you live in Mass or New Hampshire, please feel free to reach out to us. We're happy to help you with your estate planning needs. Otherwise, reach out to a qualified estate planning attorney that practices in the state in which you reside and meet with them to make sure that your estate plan is properly set up for you and your loved ones. Please like and subscribe our page below. Until next time, I'm Kelly Longtin from Kelly Longtin Law.